present and correct. Mr. Grant.
Thank you very much, my lord. I was just going to finish off on Ms. Ibbotson's report. We were at page 188 of the electronic bundle, and I was showing your lordship's para 5.26. And the point I was seeking to deploy for para 5.26 is to show that Ms. Ibbotson had adopted the approach taken by Mr. Green, and indeed that approach as a forensic tool to reaching the right, correct single question, answer to the single question posed by the authorities. And 5.26 is a very interesting paragraph because it demonstrates two things. One is it demonstrates the effect of the error as we would respectfully characterize in para 103 of the liability judgment, because there she postulates two scenarios. Scenario one is if the external storage costs had been factored in to the purchase price by the claimants, then the deduction should be nil, and that must derive from the judge's guidance. We say incorrect guidance at para 103, but it doesn't actually matter, because we then go to the second scenario. In the event that it is accepted the claimants had not factored additional storage costs into the purchase price, then the unanticipated cost of grant would be as follows, and then there we are, £120,000. That's the figure that would be, the goodwill would be reduced by, and that's the figure which should yield a direct damages award, at least in the sum of £120,000. Not, I emphasise, because that's loss flowing from, not by way of consequential loss, as loss flowing from the fraud, but as just informing the value of the asset acquired as against the purchase price paid. And let me just say one final thing. Ms. Ibbotson postulates her scenario two as referable to if the claimants had not factored additional storage costs in. I say that's all heretical and flowing from 103, but if I'm wrong on that and the heresy is orthodoxy, the judge himself found that para 27, his quantum judgment, the claimants had indeed not factored those additional costs in. They made a mistake. They were over-optimistic. They didn't believe that they would be incurred. So even assuming the judge was right in para 103, the judge expressly found that my clients had not factored in those additional storage costs, and therefore on the defendant's own case, there should at least have been a damages award in my favour of £120,000. And it's inexplicable to me, and I accept I'm coming into this case at a later stage, and I wasn't there at the trial, but doing my best to work out what had happened. Inexplicable why, given Ms. Ibbotson's own evidence, the judge didn't make a finding or a holding that leads to that extent. My lords, that's all I wanted to say about that. Now, that completes my survey of the expert evidence. I'm now going to propose to proceed to look a little at the law. I should say that over the short adjournment, I've taken something of a side to what I was otherwise going to make submissions about, largely because I very much suspect your lordships are steeped in this area of the law and don't really need that much assistance from me. If your lordships, I'm very happy to assist your lordships in any way I can. I was going to take your lordships to Smith New Court. It may be that would be an unnecessary step, and it's a case well known to your lordships. And of course, I have made reference to it at various stages of my submissions. It's very well known, of course. I was going to make reference to Standard Chartered Bank at Lord Hoffman's judgment in that case. And again, unless your lordships would be assisted by me doing so, I'm not going to do that. What I am going to do, however, if your lordships would permit me, is take your lordships to a recent decision of this court on the question of measure of damages in fraud claims. And that's a case called OMV Petron and Glencore, which is in your lordship's authorities bundle. Can I just inquire, are your lordships looking at the authorities bundle on paper or virtually?
Electronically.
Yes, same.
Me too.
The only reason I asked that question is I saw in my logistics room in my chambers large numbers of bundles being produced for the court, so they obviously haven't made their way to you, and I apologise for that. My lord, it's tab 9, but page 2, I
I apologise for not sending me paper.
No, of course not. Sorry, I withdraw the apology. I withdraw the apology immediately. Page 211, my lords, of the electronic bundle, tab 9, so far as it's of any assistance. My lords, the facts are, I don't think I need to take trouble, your lordships, with the facts. It related to the purchase of some crude oil, which had been the attributes of which had been misrepresented, so that they were overpaid for. And the question before the Court of Appeal was what value to ascribe. Obviously, the purchase price was known. The question was what value to ascribe to the oil as purchased in its true condition, and that gave rise to various interesting questions. What I was going to invite your lordships to pick up is page 219, paragraph 37 of Lord Justice Christopher Clark's judgment, where we see the learned judge starting from the fons et origo, if I can use that phrase, of the law, obviously Smith v. Court, where Lord Brown-Wilkinson's speech is, the famous passage from it is recited. Little 3 over the page at 220, in assessing such damage, i.e. the damage has been identified earlier on in that passage. Plaintiff is entitled to recover by way of damage the full price paid by him, but he must give credit for any benefits which he has received as a result of the transaction. And then we have the general rule as stated at little 4, the benefits received by him include the market value of the property acquired as at the date of acquisition. And although there was a minor quibble about the proper date, it matters not, because it was only a month or so away, and there was no difference between those two dates. Para 38 of Lord Justice Christopher Clark's judgment. As is apparent from that summary, the basic measure of damages is the price paid less the benefits received as a result of the transaction, which will, in a case where property is acquired, be or include its value at the date of the acquisition. And then for present purposes, just the date of the bill of lading. 39. In my view, that there is in this case no sufficient reason to take a different view, and good reason not to do so. There's no good reason, no need to adopt such an approach as was being propounded by the appellant, in order to relieve the fraudster from the general rule as to damages, especially if to do so means that the person defrauded ends up paying more than the cargo was worth at the time that he bought it. Particularly so in the light of the observations of Lord Blackburn and Livingstone and Raymond's Cole, that when damage is done maliciously with full knowledge of the fact doing it was doing, you would say that everything should be taken into view, which would go most against the willful wrongdoer. Famous dictum, of course, of Lord Blackburn, which is one often sees deployed. Not in any way a dictum stranded in the 19th century, by any means, still has life in it, even in the 21st century. My lords, none of that will come as any surprise to your lordships. I was going to take your lordships to Paras 58 and 59, where Mr. Southern, who was counsel for the defendant appellants, was seeking to diminish the damages that were otherwise awarded against his clients, submits it was wrong in principle to ask what the buyer would have done if he had been told the truth, relying on what Lord Steyne had said. And perhaps I can just invite your lordships to read the passage from Lord Steyne. I do not regard this criticism as well-founded. Lord Steyne's observations were designed to confirm that the deceived buyer was entitled to recover all his loss as a result of entering into the transaction, and not merely such of his loss as was attributable to the falsity of the representation. And that keys into one of the passages from the judge's judgment, quantum judgment, I think it's paragraph 28, where he deploys precisely that erroneous understanding, as we would respectfully suggest. In the present case, the buyer's loss is the difference between the price it paid and the market value. I accept Mr. Matthews's counsel for the claimant respondent. This is a generic exercise which does not require consideration of what alternative transaction the claimant would have entered into if not deceived, or a hypothetical negotiation between the actual parties. So you can't, a defendant cannot, in diminution of damages otherwise payable, set up some alternative transaction that might have been entered into. All deceit claims are necessarily no transaction claims for the purposes of establishing loss and setting damage, in setting the level of damages in my respectful submission. Can I now find the term?
Mr. Grant, before you do, could I just ask you about, see at 59, the reference to market value?
Yes, my lord.
It's obvious why market value made sense in OMV, because they were buying oil.
Yes.
But is it right that market value is the right way of valuing the asset purchased in this case?
Well,
The reason, can I just explain why I doubt it? The reason why I doubt it is because the purchaser might have made a good bargain. Because it was an asset of specific value to the purchaser in this case. For all it could have been, they could have said, well, we know the market value is with zero goodwill because the asset makes no profit, but its extra value to us means 300,000 is worth it. And in fact, it could have been a good bargain because it could have been actually, they could have made more money out of it. And it would be very strange if that's what happened, for it to be said that they suffered any loss at all, even though the market value was lower than the price they paid. You say that's not the fact, because you say you prove that it was a bad bargain. But you do have to prove that.
Well, we proved it was a bad bargain, and the defendants went along with us to quite a considerable extent by
Natural storage costs.
By their expert evidence and other points which I'll come on to. But my lord, addressing your lordship's primary submission, primary point rather, which can be taken, putting aside the facts of this case, I would respectfully suggest to your lordship that the law has to take a clear position on this, and the law has taken a clear position on this. And if once the law admitted the possibility of looking at the potential benefits to a particular buyer, which were special to it, contingent on it being able to do X, Y, or Z with the asset acquired. Once the law admits of that, the law is thrown into potential confusion, and the clarity of the law as stated by Lord Brown Wilkinson, amongst many other judges of very high authority, would be clouded, and one would be allowing interminable inquiries in diminution potentially of loss. And what I say is that the law has taken, for better or for worse, and I suggest for better, a clear principled stand on this, which is that the value you acquire is market value. Or sorry, the value that needs to be taken into account in order to fix loss is market value. Let me give you this example, which is a slight blend of an example or version of an example I've already postulated in my skeleton argument. The Picasso example. Let's say I am a dealer, I am an owner, a purchaser who buys a Picasso, which is represented, or I think buys a Picasso, which is represented as such, and I pay £5 million for it. In fact, in fact, it's not by Picasso, it's by Braque. And of course, Braque is a very famous Cubist painter, but not on a scale perhaps of eminence as Picasso. So in fact, it's a Braque, not a Picasso, from the Cubist period of both their artistic lives. I have got a Braque worth, the market says worth £100,000. I thought I paid £5 million because I thought it was a Picasso. Let's say it so happens that I, as a purchaser of early 20th century art, have another Braque, which is part of a similar series. Now, it may be that Braque is worth more to me because I can then sell both Braques together worth to me with the other graph £200,000, whereas in the market it's worth 100,000. Now, it'd be quite wrong, my respectful submission, that the law would start making inquiries into what other paintings are in my collection to work out whether my damages should be £4.9 million or £4.8 million. My lord, I don't know if that's a helpful example. It's one that's occurred to me.
Let me put something against you on that, which is Smith New Court itself, which doesn't say market value. It says that this is sub 3 that you pointed out in Lord Bell Wilkinson.
Yes.
Give credit for any benefits which he has received as a result of the transaction. So that's the question, as posed in Smith New Court, is what benefits did the purchaser receive? And if you in fact received a benefit by having an asset which you can sell for £200,000, the fact that someone else could have sold it for £100,000 doesn't change the fact that in your hands it's worth £200,000.
It's only worth £200,000 contingently because you buy some pure happenstance, happen to have the sister or brother painting. And I would suggest that I mean, I've not done an in-depth research into how the law fixes market value or what other judges have said, and I haven't done that for the purposes of preparing this appeal. I do notice a little form of Lord Brown Wilkinson's speech. The benefits received by him include, as a general rule, the market value of the property acquired. I suppose your lordship might say, well, that's a general rule.
Of course, exactly.
Well,
I mean, the reason I'm putting it to you is because in this case, what I'm troubled about is the idea that your client should be able to recover on the basis of saying that the goodwill is zero because it was loss making, when that was factored into the purchase price. That was something, and the reason the goodwill had a value, the reason the price was being paid above the fact it was a loss-making business was because it had a value to the purchaser. Now, hang on a second. Okay. Now, I understand why you say, as a matter of principle, if you can show that your client made a bad bargain, then the loss flowing from the transaction, because it was a bad bargain, is loss your client's entitled to cover. I agree with you about that. I see that. I see the force of that, subject to the other problems that may or may not exist. But what I'm troubled about is that you do need to prove it was a bad bargain, because it might have been a good bargain. And if it was a good bargain, then you didn't lose anything. Your client didn't lose anything.
Well, okay. I'm going to answer that question this way, if I may. The reality is the only reason my client ascribed a £300,000 value, allowing it to pay £300,000 or encouraging it to pay £300,000 for the goodwill, was because of a series of assumptions which turned out to be false. So there's no question, and nobody suggested that, so far as I'm aware, that in fact the goodwill did indeed have a value to my client. It was thought to have a value to my client by my client, but it was only thought to do so because of errors and misconceptions that my client was proceeding under at that time. So even if your lordship is right, which I respectfully question and challenge, even if your lordship is right that the claimant in any case has to give credit, and I'll come back to burden of proof, because there's another point on burden of proof, I'm going to come back to that, has to give credit for the actual benefits to it in the position it was in when it acquired the asset. What credit could there be given in this case? Because the only reason the £300,000 was ascribed to it was because of a series of misconceptions as found by the judge. Nobody was suggesting, so far as I'm aware, that this company, apart from the stock which could be priced and the plant that could be priced, which was priced, we're not making any claim in respect of that. Hence, we're not claiming the 750 or the 203,000 that was paid over. We're simply combining ourselves to the 300. Nobody is suggesting that it had an actual value. What the judge is saying is, the reason you overpaid was not because of fraud on the part of the defendant, because of your own misconception, and therefore that shouldn't fall to the.
No, I understand. I understand why you say that's right. Because you say I understand. I mean, in my terms, your answer to me is you say it's obvious it was a bad bargain, or maybe it is.
Well,
but all I'm putting to you, Mr. Grant, is it seems to me that it's a necessary part of your case that it was a bad bargain. Because if it wasn't a bad bargain, then your client didn't suffer any direct loss from entering into the transaction.
Well, undoubtedly, the actual value of the asset I acquired
To your client.
in market, well, this is where we may differ, but to my client was 300,000. But no, but I don't think anyone suggested it actually had a value to my client. It was thought to do so, but those thoughts were founded on misconceptions and errors which my client was forced to confront. But my lord, there's a further point here, which is burden of proof. And we, in our skeleton argument, have suggested to your lordships that the proper approach to burden of proof, this is an entirely freestanding point, I should say, is that when a claimant has acquired an asset for a sum of money and is paid over that sum of money pursuant to the fraud, then the proper approach is as follows. I, as the claimant, say I've paid over £300,000. The burden of showing the value of the asset acquired is plainly upon the defendant. And let's see how the Court of Appeal said that in Petrol. Para 88, please. Page 230. And instead of reading it out, I'll perhaps invite your lordships to just read para 88. Glencore, of course, was the defendant. And my lords, that approach is echoed in a decision which, in order to try and not burden the court with too much material, we haven't included in our bundle of authorities. Perhaps we should have done, because actually, having reread it last night, it's a rather interesting judgment called Para Imports and Radivan. And it's referred to in our skeleton argument at para 29. This is page 59, I believe, of the core bundle, where we make this point of para 4, page 59 of the core bundle. This is my skeleton argument, I should say. The onus of proving the loss suffered by C's lies on C's, but the onus of proving facts that result in the abatement of that loss lies on D's. We quoted from Lord Sumption's judgment in Hughes, Holland and BVP. We then cite parallel imports. In fact, I think, having considered it further, I think parallel imports may be a decision which will be of assistance for your lordships to see. Can I just preview it, so to speak, now? Essentially, in that case, the defendant had fraudulently misrepresented to the claimant that certain cars were available for the claimant to purchase. As a result of that misrepresentation, the claimant paid a sum of money to a dealer who was to supply those cars. In fact, no cars were available to be supplied, and the money transferred to the dealer by the claimant was kept by the dealer on the basis, this is the critical point, that the dealer had other claims against the claimant against which it offset the payment received. And Mr. Radivan, who was the defendant, argued that there was no loss to the claimant because the monies paid over to the dealer simply being credited against sums it already owed to the dealer. And Lord Justice Wall, and I'm sorry to be reading this out without you just having this in front of you, and I apologise for that, I'm going to provide you with a copy overnight. Writ says this, let me quote, as already explained, Bagland, that's the claimant, have proved that a fraudulent misrepresentation was made by Mr. Radivan to it, and that Bagland was induced to make a payment to Prince, that's the dealer, that it would not have otherwise made, that the cars paid for were not available, and that Bagland was not repaired. In our judgment, so it had made the money, paid the money over, and what didn't receive the money back, the claimant. And in this critical phrase, in our judgment, it was for Mr. Radivan, i.e. the defendant, to adduce evidence showing that Mr. Bagland had in reality suffered no loss by making the payment, because the Prince was entitled to keep it in respect of Bagland's existing liability to it. I.e. it was for the defendant to prove that in fact the dealer money had cross claims against the claimant, which allowed it to set off the sums it received, so that the claimant had made no loss. It wasn't for the claimant to prove to the court when seeking damages that in fact there were no cross claims by the recipient of the money, ergo the loss was a full loss. My lords, the burden was on the defendant to prove that for the £300,000 that had paid over, my clients received an asset of value to the tune of £300,000. It failed to do that conspicuously. Even if the burden was on me, it's clear that we proved that that the value was not £300,000 and indeed was nil. And my lord, I referred to methodology 1 and methodology 2. Methodology 2 was the simple proposition, unchallenged so far as I'm aware, set out by Mr. Green, that a loss-making business has no value. As I say, not a revolutionary proposition. And in that context, before I leave the law, and I'm going to leave it almost instantaneously unless your lordships want to detain me on any further point, can I just show your lordships another decision which is in your lordships bundle, which is a decision called Karim and Weems. It is page 168, tab 6 of your lordships authorities bundle. Again, this is a decision which I don't think I need to show your lordship, tell your lordship the facts of. That it's another misrepresentation case, and the question is what damages flow from entry into the transaction. And it's paragraph 49, page 181. And it's the first 8 lines, which I'd invite the lordships just to look at. It may come as no surprise to you, I quite accept. And for good measure, we've also put in a short extract from a decision of Mr. Justice Roth in a case called Shah and Shah. I don't take your lordships to it, but for the purpose of your lordships notice, page 253 of the bundle of authorities, where the experts in that case, which was an unfair petition case, agreed between themselves that because the profits of the company were nil, the business had no goodwill value. I mean, that's an agreement between experts recorded by the learned judge. But again, just an example in support of the proposition made by Mr. Green in his expert reports, as I've showed your lordships, that's Shah and Shah in the relevant the page I mentioned. My lords, those are all the submissions I wish to presently make about the law. I now turn to my specific grounds, and obviously a lot of the submissions in relation to the 5 grounds that found my appeal have already been the subject of some preemptive submissions. So I'm hoping not to take this too long, but there are some submissions I need to make to your lordships. Can I invite your lordships to pick up my skeleton argument, which is core bundle, tab 9, page 50. I think it's page 60 of your lordships electronic bundle. This is, the grounds themselves are elsewhere within the bundle. I don't think I need to take your lordships to those. Just for your lordships note, the grounds are at page 25. But the skeleton argument follows them quite closely, I hope, and believe. And my lord, so ground 1 is simply this, that the judge below failed to do the very task which he was bound to do by the law, and which Mr. Dagnall had repeatedly invited him to do, as we have seen by reference to the judgment itself. I've shown your lordship a number of occasions where Mr. Dagnall said The simple, final, only question is, what is the value of the assets acquired? And the judge conspicuously, we respectfully submit, notwithstanding his recitation of Mr. Dagnall's submissions on a number of occasions, didn't do that. The only losses that were in fact awarded to Glossop were, as I have said, 2 heads of loss of a comparatively minor nature relating purely to consequential loss. And again, just to repeat, that is the loss of £6,000 odd in relation to a temporary electricity supply that was necessitated by the fact that the electricity was cut off by Mr. Scotlock, who you may remember features in the first judgment as the neighbour who had an animus against Mr. Smith and had all sorts of litigations with him. That was head of damage 1 by way of consequential loss, and head of damage 2 was the cost bound up with the barrister's determination 2 years later, which I don't think I need to say anything more about now. That's the totality of the loss of the damages awarded in favour of Glossop. There was simply no loss at all recorded in respect of direct loss, i.e. Lord Brown-Wilkinson's first head of loss. And it's not, and there was no even attempt to address it in my respectful submission. What the judge, and your lordships have my submissions at paras 32 to 35, and I'm not going to recite them to your lordships, but this is probably an opportune moment to go back to the quantum judgment. Your lordships have been, this is starting at page 162, but your lordships have been shown with some, I hope, quite a lot of detail and some care by me, the judge's sort of holdings on the law. And then, having made those holdings, the judge then proceeded to consider what he describes as a schedule of losses. And this is at page 175 of the judgment, my lords. I hope your lordships are at paragraph 30 of the quantum judgment now. Where the judge says, against that background, I turn to the schedule of losses. And the schedule of losses was in fact a Scott schedule, which is in your lordship's supplemental bundle, and which was the various items referred to by Mr. Green as being items to deduct on his pound-for-pound forensic analysis to get forensic tool, to get to the true value. Now, the judge, with the greatest respect, seems to have entirely misunderstood that schedule. He seems to have treated it as a schedule of loss in the strict and understood sense of the term, i.e. a schedule of claims which I, the claimant, am seeking damages for. But that's not what it was. It was a schedule setting out all the figures that should be deducted from the 300,000 figure on the pound-for-pound approach, which Mr. Green had adopted as his methodology 1, and which Miss Ibbotson had adopted as well. So when one sees at paragraph 30, I turn to the schedule of losses, we're already potentially seeing an error creeping in. Now, items 1, 2, and 3 don't need to detain your lordships because they were the subject of separate awards under different heads, which are not before your lordships on this appeal. They may to some extent be on the cross appeal. I'll leave that to my learned friend. So your lordships don't need to trouble your lordships with paragraphs 30, 31, and 32. We are now at paragraph 33, page 176 of the electronic bundle. Now, we turn to what are known as items 4 and 5. And for the purposes of my submissions now, it's not, your lordships don't need to get too troubled by this. So we can look at it simply on the face of the judgment. Items 4 and 5 of the Scott schedule are additional transport and storage costs due to maintaining 2 sites and the additional costs of maintaining the Glossop depot. The lordships will remember that the hope and expectation of Glossop when it bought Contact was that it wouldn't need to have two sites. This was this wonderful one-site solution, which proved to be erroneous. Now, for the purpose of the current submission, the judge treats items 4 and 5 as if this was a damages claim, a freestanding damages claim. In fact, it was primarily put as an overpayment claim, i.e. not a claim for loss in itself, but simply a sum of money which the claimants did not expect to have to pay, priced the asset accordingly, and then turned out they did have to pay it. And therefore it goes to the pound-for-pound methodology. So it's just paragraphs 33 to 36 are just, with the greatest respect to his lordship, are inexplicable, because he's entirely misunderstanding what their primary purpose was. And we can see that at para 36 over at page 175.
He wasn't very much helped, Mr. Grant, by the categorisation of these losses in the claimant's comments, was he?
Your Lordship's looking at the schedule, the Scotch schedule.
I'm looking at the Scotch schedule.
Bundle, yes.
But to take the temporary minor supply to Unit 3, I know this isn't the point you're on at the moment, but it's just the first line. It's categorised as an actual cost and an OP loss and an RM loss and a CL loss.
Is that item, I'm sorry, by the way, is that item 1?
It's item 1, yes.
Yeah, this is page...
page 199 of the printed, but I mean, probably the same point can be made about item 4, which you are talking about. Loss and a CL loss.
Yes. Well,
which reflects, I think, the way that the experts were approaching it by treating consequential losses as a method of arriving at direct loss.
Well, it was the primary way it was put, and one sees this in the expert report of Mr. Green, which I've shown your lordship, and it's particularly para 220, where you may remember he starts with his 300 figure, he then deducts 2 figures to get to a minus figure. Your lordship may recall that. And it's right that it's put as an OP and a CL loss. I mean, that doesn't the fact that it's put in 2 different ways doesn't alleviate the judge of the task and obligation of actually addressing the case as put primarily. The case as put primarily was that these are costs which were not anticipated. Whether or not they flowed from the misrepresentation or was entirely irrelevant. They were costs that built into and explained the overpayment and therefore reduced the value, if one uses methodology 1 as I've called it. And one can see the error, I would suggest, at para 36, which is page 177, core bundle, where 6 lines from the bottom, I do not see that that represents an element of recoverable loss. But that's not primarily how it was being put. And your lordship can read on to the end. I do not see that these items represent losses that have properly flowed from the entry into the transaction. Again, that's not how it was primarily put. These are not consequential losses in the primary case. And so that's all I wanted to say about paras 33 to 36. We then go to para 37, which is item 6. And that item...
What are you saying, Mr. Grant? I mean, are you saying that we should allow items 5 and items 4? Or are you saying that we should allow 300,000, which is what you say in your skeleton? Or are you saying we should send it back for a retrial on the proper basis? Or what are you saying?
My lord, I am very diffidently presenting to your lordships all the difficulties and errors that have crept in to the judge's reasoning. There are various options available to your lordships. The easiest way forward would be, in my respectful submission, if you were with me on my submissions, of course, I don't want to be in any way presumptuous, would be simply to say it's patent that this goodwill had nil value. This was was a massively loss-making company. We have evidence from Mr. Green that says that. There's no contradiction to that. We don't need to worry about the methodology one. It's obvious under methodology two that there was nil value to this. We will enter judgment for £300,000 and allow the appeal accordingly. But I'm a realistic person, and I accept.
Where does that leave all the other claims?
Well, that would be the end of the matter. There would be no that. Given that my only appeal relates to is an appeal by C1 and C1 alone. I would be content with such a disposition. But as I say, I'm a realistic person, and it may be your lordships take the view this is all extremely complicated, and we're not going to start going into all these points. And we see that the judge got it wrong. Here's the proper approach, as set out definitively by this court, and remit it back to Judge Hodge or some other judge to get it right on the right approach. That is another alternative. And I don't want to.
Okay, just hang on a second. Just assume we're with you on the value point, and we think that it's a no-brainer that the judge ought simply to have said this company had no goodwill, and therefore it was 300 equals naught, therefore you were entitled to 300. Where does that leave the consequential claims and the contractual claims for the independent barrister, for the £6,000 temporary power supply, the indemnity against Miss Brannigan's claim, and so on?
Nobody has no effect on them at all. Nobody's suggesting otherwise. Mr. Berrigan has a minor, I don't want to say minor point, I don't want to diminish it, it's a point that he'll make.
It's not an IB point.
I'll meet it. He has a capacious investments point, which I will meet. But putting aside his cross, it just involves you entering judgment, assuming everything else in my favour, for £300,000. It's as simple as that. I accept that your lordships may think, well, this is all very complicated. We're not prepared, sitting in this court, to just simply proceed on that basis. I urge you to do so, but I'm a realist, and I'm not somebody who wants to have all his eggs in one basket. So there is that.
Eggs. It's a question of some massive costs. I mean, if you're right, are you really urging us to order a retrial? And let's say you're right, that the judge approached it the wrong way. The exercise that should have been done is to approach it by asking what the value of the assets purchased were. And the answer to that question is not more than whatever the price paid less 300,000. So the difference is 300,000.
Yes.
And there is no issue on consequential loss. What on earth is the point in sending it back to the judge or any judge?
If you were to do that, I would not be in any way cavilling against that. I should immediately say.
You do sort of sound as if you are. That's
no, I don't want to start arguing against myself. I'm just simply saying I accept there's a conceivable world in which your lordship say the judge got it wrong. We're not going to take any further steps, and we're going to remit it. That is a conceivable world. But I obviously would encourage your lordships to so to speak, just give this case its quietus now.
I mean, as I understand it, you say that the defendant has to prove if the purchase was of greater benefit to you.
Absolutely.
And they haven't proved that, at the very least. And so my lord's point is not, even if correct, is not relevant here, because they have failed to prove that this business was worth much more to you than you paid. And in those circumstances, it's you're only asking for 300, not for 500, or what is the judge for 450 or whatever it was. So if you're right, that should be an end of the matter. And you point out that Miss Ibbotson agreed with the approach.
Well, exactly right. I can say no more than that. I'm going to be short. The rest of the judgment is only 2 pages further. I'm just going to deal with it pretty quickly, if I may. Item 6, page 177, para 37. Again, treated by the judge as a freestanding claim in respect to which judgment was being sought. It suffers, I mean, I might as well take the point now, it suffers from further problems, the judge's analysis of item 6. If one goes to para 38, one sees at the right at the bottom of the page, Mr. Berrigan points to the fact that in para 96 of his earlier judgment, I'd found that there were clearly major problems faced by the business quite independently of the problems affecting Unit 3. The frauds related to Unit 3, of course. So this is Mr. Berrigan appearing to adopt or encourage the judge to effectively say that losses flowing which were not somehow causally related to the frauds don't fall to be compensated. The judge is encouraged by that and seems to agree with it. I recorded that Mr. the Glossop had effectively overreached itself, underestimated the dividends involved in integrating the two businesses. Glossop has simply failed to achieve the volume of orders for which it was hoping, quite independently of any issues related to Unit 3. Again, we see the error creeping in. Mr. Berrigan reminds me that at para 97, I rejected the suggestion that business had gone downhill as a result of the problems with Unit 3. I recorded that business had fallen to decline long before Unit 3 had actually been intended to be used. And then finally, the loss of turnover claim, a false designation, predicated on the false assumption that we have a smooth transition, benefiting both the Glossop and contact businesses on an integrated basis. That assumption has proved to be false. It does not seem to me that that gives rise to any recoverable loss. We see the error in action in those very words, in my respectful submission. They were founded on, i.e. the purchase price was founded on a false assumption about certain economies that could be made. Those economies were incapable of being made. That led to the costs, these costs being incurred, which were deducted under methodology 1. Item 7, I don't need to trouble your lordships with. We now have only 2 further items to go, which is items 10, para 40, and items 11, para 41. So let's go straight to para 40, which is page 178. Now, I need to spend a minute just explaining item 10. It is now clear that Glossop would never have contemplated and never expenditure postulated by Mr. Mills. Now, you're going to think, what on earth is all this about? Let me just explain. Mr. Sidebottom, who was one of the principal witnesses called by the claimants and one of its directors, had given evidence to this effect. He, when offering to buy the contact business, he had assumed that it would be possible to convert Unit 3 into a digital printing suite at a cost of £50,000. And he priced his bid, or Glossop's bid, accordingly. Just like if I'm about to buy a house and I see that it's got a 1970s kitchen, which I wish to update into a 21st century kitchen, and I think it will cost me £50,000 to create a habitable kitchen for myself and my family, the fact that I think it will cost £50,000 rather than £100,000 will obviously influence the overall price I am willing to pay for the house as a whole. It's as simple as that. It turns out that the £50,000 that Mr. Sidebottom had erroneously thought it would cost to convert Unit 3 into a digital printing suite was a dramatic underestimate of the true cost. And Mr. Mills was the expert who costed the actual cost of getting to a digital printing suite. And he put in an expert report, which nobody challenged or cross-examined on, that the true cost was £222,000. And hence, that explains the figure of £172,000 that your lordships may have seen in Mr. Green's report, as being, there was going to have to be an additional £172,000 of expenditure, uncosted and unanticipated by Mr. Sidebottom and therefore Glossop, to get to where he wanted to get to, where he thought he was going to get to, by paying out £50,000. Now, the judge himself at para 15 makes a finding that that costing of £50,000 was a gross underestimate. Whether it would have cost £252,000 or not was never finally resolved by the judge, although he took the view that it was never going to cost £222,000, largely because Mr. Sidebottom, confronted with Mr. Mills' expert report and showed all the costs that Mr. Mills had put in to get to the £222,000 figure, which was the figure to convert it into a digital Unit 3 into a digital printing suite. Mr. Sidebottom appears in the witness box to have said, no way was I going to spend that kind of money, this is ridiculous. And that explains the judges, it is now clear that Glossop would never have contemplated the level of expenditure postulated by Mr. Mills. Therefore, and then this complete non sequitur. Therefore, the claim for the difference between Mr. Mills's cost is bigger than 222 and what was effectively the guesstimate of Brian and Jackie, the two directors of Glossop, of 50,000 fails on the facts. That is, with the greatest respect, a completely inexplicable thing to say. Nobody was claiming that the difference between 50 and 222 as damages. The point that was being made is that my clients had been willing to pay 300,000 on the false assumption it would cost 50,000 to turn Unit 3 into a digital printing suite, i.e., they falsely assumed certain attributes of the business and overpaid accordingly. So to convert that into a claim for £172,000 as failing on the facts is just meaningless, with the greatest respect. And then he talks about it being entirely subjective to Glossop as the actual purchaser. But again, that's not the purpose for which these figures were being deployed. The purpose was to deploy between both. That my clients had gone into this and ascribed a false value to the company because of false assumptions about what the attributes of the assets and what it was capable of and what it was not capable of. So the whole of paragraph 40, with the greatest respect, involves multiple misunderstandings by the judge as to the obvious and clear nature of the case. That's all I wanted to say about 40. 41 is the final paragraph. That's item 11.
I think it would be difficult, but I mean, as my lord pointed out, if you go back to the Scotch schedule, you said this is an overpayment loss and a consequential loss.
Well,
so the judge was treating it as a consequential loss. He treated it all as consequential loss.
well, I mean, I can't speak to why it was put in as an OP and a CL. No doubt it was being put in every form in order to cover every conceivable base. But the primary way it was analysed in Mr. Green's report, as your lordships have been shown by me with some care, possibly too much care, was to say it was a pound for pound deduction because essentially we were prepared to pay 300 on a false assessment as to how much it cost to do something. And that was agreed by Miss Ibbotson as well. If you look at her own report, she's willing to deduct £172,000 herself.
Why are we looking at all this stuff about item 6 and item 7 and item 10 and item 11? If your case is this was a loss-making business that was worth nothing, and we paid £300,000 and want it back, please.
Well, it's a very good question, my lord, and I do see the force of your lordship's point. I'm doing it because I don't want to be seen to be in any way evading what the judge said, or trying to run away from it, or trying to scurry out from some escape hatch. I want to show your lordships that I'm confronting and willing and able to confront the way the judge actually dealt with this, and to show that even on his own terms, he was wrong.
Well, he dealt with the whole thing as consequential loss. Perfectly clear.
Well, and look at paragraph and item 11. This is the final paragraph. It's a short paragraph. I want to make good on my refusal to run away from the weeds of this case. And I refuse to do so, because I don't want it to be said against me by Mr. Berrigan. Mr. Grant couldn't bear the facts. He had to keep away from the facts. The facts help me, because the facts and the actual reads of this judgment shows the error. And look at item 11. You've already heard an awful lot about storage charges, and possibly more than you'd ever want to hear about storage charges. But look at the way it was dealt with in the last sentence, a very long sentence, para 41. Starting with these words, it does not seem to me that these additional premises costs could properly be claimed. That relates to £25,000, let's forget about that. But in any event, for the reasons I've already given, it does not seem to me that anything is properly recoverable as damages for fraudulent representation for additional storage charges, as if we were claiming them simply as consequential losses. They were the product of over-generous assessment of the benefits to be gained by entering into this transaction. That's true. I do not consider that feeds into a claim for damages and fraudulent representation. That's not the point, with respect, my lord. My lord being Judge Hodge there, who I'm notionally addressing. It's clear that the judge's holding at paras 27 and 28 about over-generous assessments is feeding in here again, yet a further error. And literally, the judge said literally nothing about Miss Ibbetson's own agreement that 120,000 should come off. And I've shown your lordship what Miss Ibbetson said at paras 212, 5.37 and 5.26. I don't think I need to show your lordship. And how that they were not, on Miss Ibbetson's own case, these were not costs, even if it's a valid analysis, which is not, costs factored into the purchase price. So, my lords, the rest of the judgment doesn't need to be troubled. Item 9 is the independent barrister. So, my lords, we say the primary head of ground of appeal is simply the judge's failure to conduct the very task all the judges for the last 140 years, since at least Lord Blackburn has tasked judges to do. He just failed to do it. And he failed to do it because he appears to have treated the claims as being somehow consequential loss claims, when they were not, primarily not consequential loss claims. And your lordship knows the point. My lord, I was going to address my learned friend's counter submissions in his skeleton on this. In the interest of time, perhaps I'll just leave my learned friend to make his submissions. I don't understand them at all, with the greatest respect.
Sure, that's a helpful submission.
No, it's not a helpful submission. I withdraw it.
I'm confident you will understand them when you've heard them, and then you can apply to them in the usual way.
I will not address them. I will not address my learned friend now. My lord, that's ground 1. Ground 2 takes us back to my skeleton argument, back to tab 9, page 61 of the judgment of the electronic bundle. The judge erred by excluding losses that were the product of commercial misjudgments. I've shown you the very many occasions when the judge, having made his holding of law, then utilizes and deploys that holding of law when dealing with individual items. My lords, we've made a number of submissions at para 38, which I am not going to recite in detail. What is clear is that the error starts at para 103 of the liability judgment, and it is notable, my lords, that the learned editors of Clark and Linsell have already expressed their doubts about the correctness of what the judge said at the liability stage. The quantum judgment doesn't appear to have found its way onto their desk yet to express a doubt about. But can I, or to agree with, I don't, as the case may be. But if one turns very briefly back to the authorities bundle, please, page 447 of the authorities bundle, forgive me, page 446, please. This is Clark and Linsell, the most recent electronic edition. One sees the editors saying the following at 1748. The claimant in deceit must, of course, show that his loss results from the misrepresentation of defendant. The better position is that the claimant is not limited to such losses as are suffered in connection with false representation, but recover all losses directly resulting. Your lordship then sees footnote 232, page 446. Your lordship please turns to 447, and we pick up footnote 232, where it is said the apparent contrary suggestion in Glossop, this is the liability judgment of 103, that paragraph we've looked at so often, and then your lordships can read on. And we respectfully endorse the doubt expressed by the learned editors of Clark and Linsell. That's all I wanted to say about that. My lords, we have in our paragraph 38, we have deployed what I hope is a helpful example, which is not precisely the same Braque-Picasso example that I engaged with Lord Justice Birss with, a slightly simpler version. We respectfully suggest that in the scenario we postulated little 2, page 63 of the skeleton argument, the answer is obvious. If I, as a fraudulent art dealer, tell my prospective purchaser that I am sitting on a Picasso, and the purchaser pays £10 million for that Picasso, and it turns out it was by a follower of Picasso, worth £100,000. But it also turns out that if it had indeed been by Picasso, it would have been worth £5 million. My damages are not 4.9 million, they're 9.9 million. And the notion the fraudulent art dealer can say to the defrauded purchaser, well, the fact that you chose to pay an additional 5 million is your own lookout. And I can keep, having parted with a painting worth £100,000 through my own deceit, I can keep 5.1 million of the purchase price to be paid over and only be required to disgorge 4.9 million pounds, is respectfully heretical. But that is precisely what the judge's reasoning requires. And indeed, it has a precise, albeit perhaps more prosaic, analogue in the facts of this case. The judge, and it translates precisely, this is not some exotic example designed to bamboozle the lordships. It's designed to cast the clearest light on the proper disposition of this appeal, because the judge appears to have proceeded on the basis that if the claimants paid £300,000 for the goodwill of the business on the basis of their own carelessness and over-optimism, just like the purchaser of the Picasso who thinks, oh, I'll just pay 10 million over because he's an oligarch, he doesn't wreck the price. Then, insofar as they overpaid because of their own carelessness or over-optimism, then that loss must fall to their account. And that's what the judge says. That's what my learned friend Mr. Berrigan says, and said at first instance. And your lordships are confronted with a very clean point of law, to which I say the answer is absolutely clear. And that the limiting principle that the judge seems to have arrived at is a heresy with respect, which your lordships, I invite your lordships to explode and stamp out. My lords, we spend a good deal of time making various submissions on that point, and I'm not going to delay your lordships any further by going through those submissions. But I should just say again, I've been through it once. I'm not going to do it again. But if your lordship just see the judge in action on this, paras 27 to 29 and the 41 of the quantum judgment, dealing with the storage costs, you see a precise example of how the heresy actually has cash consequences. That is my ground, and I will say no more about it. Ground 3, my lord, is at page 66. Of paragraph 40. And can I just, because I'm conscious of the time, can I just give your lordships the relevant paragraphs where the judge engages in what appears to be material speculation about what might have happened had the truth been known or some other representation been made. Your lordships note, paras 54 to 55 and 76 of the liability judgment, and indeed para 103 of the liability judgment. And my lords, putting it very bluntly and simply, we say it is just wrong in a case of deceit. Once one has proved the materiality of the submission of the representation, i.e. once one has proved what is generally described as inducement in the authorities, then one goes no further.